In this scene, the deposing attorney representing the plaintiff, Sarah Hostetler, is Marcus Peterman. He is deposing Acme's Vice President of Human Resources, Sandra Lee. Ms. Lee is being defended by Acme Internal Legal Counsel, Leslie Davis.
Ms. Lee, would you please state your name and title for the record?
Sandra Lee, Vice President, Human Resources, Acme Financial Services.
Thank you. And how long have you been in Acme's HR department?
9 years.
And in your 9 years, you have been involved in a number of hirings and firings. Is that correct?
Of course.
If you had to guess, how many terminations have you been involved in?
I have no idea.
Would it be fair to say it's been in the dozens?
Objection. Asked and answered.
Well, that wasn't my question. My question was if a fair estimate would be dozens of terminations.
Objection. The question's been asked and answered.
Ms. Lee, for the purposes of our discussion today, would it be fair to say that you've been involved in many terminations?
Objection. The question's been asked and answered. Ms. Lee stated she has no idea how many terminations she's participated in. Please move on.
It's okay. For the purposes of this discussion, sure, I've participated in many terminations.
So of the many terminations that you have processed, how many were violations for the company's communication policy regarding the use of personal communication and messaging devices to conduct business?
I'm not at liberty to discuss cases other than Ms. Hostetler's.
Well, is that your answer or your attorney's?
Mine.
Can you think of even a single instance where a termination for cause occurred in violation of this policy?
Objection. Form. Ms. Lee is here to discuss Ms. Hostetler's case, no one else's.
I'm not asking you to discuss any particular case. I'm just trying to get an idea of how many of the terminations involved the communications policy Ms. Hostetler allegedly violated. Were there many? A few? 10%? Perhaps zero?
Only a few that I can recall.
So you're saying that when terminating an employee for cause, your company's policy regarding the use of personal, texting, and email accounts is rarely invoked. Is that correct?
Only as in Ms. Hostetler's case, when the violations involve particularly sensitive information passed through non-work accounts and the behavior is egregious in its frequency.
Oh, egregious in its frequency. That sounds like legalese to me. Is that another answer Ms. Davis gave you during your coaching session?
Objection. Harassment. Please stop bullying the witness with unfounded accusations.
Oh, unfounded accusations. Well, you two make quite the team. Isn't it true that not one other single employee who, using their personal messaging or email accounts, was terminated or even reprimanded?
The others received messages. They did not initiate them.
Answer the question, please. Was any other employee using their personal messaging or email accounts terminated or even reprimanded?
No individual employee, but
Thank you. So, in fact, no additional...
Excuse me, counselor. Could you please let the witness answer the question?
Well, asked and answered. Well, thank you. So no other individual employee in egregious frequency and in violation of company communication policy was treated the same way Ms. Hostetler was.
No, but all employees...
I'm not asking about all employees, Miss Lee. I'm asking about the individuals with whom Ms. Hostetler corresponded.
Why are you shouting? I'm trying to answer your question.
No, you're not. You're trying to distract by inserting an immaterial, corporate-wide communications policy statement into the record of a very individual case where an individual was singled out as a pretext for termination when you and your company know that this behavior is widespread.
Ms. Hostetler's case was unique. She
was doing the same thing a lot of her colleagues were doing. In fact, in spite of her actions being egregious in frequency and the types of information shared, isn't it true that no leak of confidential information resulted as her actions?
That's not the point.
What's not the point?
That no leak resulted. She put...
Good. Thank you very much. Thank you for confirming that, in fact, no leak of confidential information or harm at all came to the company as a result of Ms. Hostetler's actions, and that her termination for cause was instead a mean-spirited ploy to avoid paying her the bonus that was due to vest just weeks after she was fired.
That's enough. Objection, harassment. Let the record show that in addition to raising his voice, refusing to let the witness answer the question, and injecting his own answers, that Mr. Peterman is leaning across the table toward my client, gesticulating wildly. And if he doesn't back off, I'm going to move to suspend this deposition.
Oh, no need to suspend. I'm done with this witness.
Oh, excuse me, counselor. You have nothing more?
We have what we need.
For the record, attorney for the plaintiff has stated he has completed his questioning of Ms. Lee. I, Leslie Davis, attorney for the defendant, Acme Financial Services, will now cross-examine the witness. Ms. Lee, you testified that no individual employee with whom Ms. Hostetler communicated via personal text or email account was terminated or even reprimanded. Could you please explain what the company did do?
As soon as we fully understood the extent to which Ms. Hostetler was using personal text and email accounts, we sent out a corporate-wide reminder of our policy, its importance to protecting ours and our clients' confidential information, and required all employees to recertify they understand and will comply with the policy.
So despite the fact that you essentially issued a warning to all other employees, the company decided to terminate Ms. Hostetler. Why was that?
As I mentioned, Ms. Hostetler's case was unique. This was not a single nor the first such offense. Her violations involved particularly sensitive information passed through non-work accounts. And when we looked into it, we discovered the behavior was egregious in its frequency.
You also testified that no leak of confidential information resulted from Ms. Hostetler's actions. Why was that not an important fact when deciding termination for cause was an appropriate response?
The fact we didn't experience a leak or a hack doesn't diminish the fact that by flaunting an important company policy, she repeatedly put the company at risk not only of a data security breach, but also of substantial fines from regulators.
Thank you.